Welcome, everybody. My name is Josh Sharfstein. I'm the Vice Dean for Public Health Practice and Community Engagement here at the school and Director of the Bloomberg American Health Initiative, which is really pleased with the Office of Public Health Practice to be sponsoring this really great talk. This is going to be a really special hour. I'm just thrilled to be here to introduce Professor Martha Jones. She is the Society of Black Alumni Presidential Professor and Professor of History here at Johns Hopkins. She works over at Homewood. She was formerly a Presidential Bicentennial Professor at the University of Michigan and the founding director of the Michigan Law School program in Race, Law, and History. And she's going to be talking about her most recent book called Birthright Citizens, A History of Race and Rights in Antebellum America. And this is a story about history. It's a big story, an amazing story about Baltimore. But it's also a story that has all kinds of resonance for today. And I just want to read a little bit from her introduction, where she wrote, "No work of history is a blueprint for the present, and too much has changed between the 19th and 21st centuries to permit us to prescribe remedies for today based on the lessons of the past. Still, the case of free people of color and their struggle for belonging will read to some as a cautionary tale. And Birthright Citizens is guided by questions that are resonant in our present day. How, we might ask now, as Americans asked 200 years ago, should we regard those among us whose formal relationship to rights and citizenship remains unsettled and a recurring subject of political debate? What cost is there to be paid by a nation that permits people to work, create families, and build communities within its geopolitical borders, but then declines to extend them membership in the body politic?" We might say that the people that she describes in the book are not unlike today's unauthorized immigrants and their children, at least to the degree that free people of color then were also a community that lived through episodes of punitive legislation and efforts to force their exile. Birthright Citizens is their story. So, even though this is about history, history really has a really important role to play in understanding of health challenges. And this history has a really important role to play, not only to understand Baltimore, but also to understand the present. And we are so lucky to have Professor Jones here. She told me she has 4 talks this week alone in various cities. She is the, global expert in this topic that is, for many reasons that are unfortunate, a very pressing topic today. So just so thrilled that she's here. Now, I have to prepare everyone for the fact that she is actually going to speak to us and not use slides. Oh. Okay, so that is like So this is something that lawyers sometimes do, and sometimes it makes physicians very, very anxious, but public health students can handle it, I think. So she's going to speak, and she's also going to be open to questions, and I really am just so pleased. Thank you so much, Professor Jones, for coming.
My pleasure. Good afternoon. Good afternoon, folks. Thank you. I didn't know about the slides part, so forgive me because I do want to just talk with you some today. And I thank Dean Sharfstein for the kind introduction and for those words from Birthright Citizens because I wrote those words, I guess it was the fall of 2017. I had just arrived here at Johns Hopkins and found myself living in Baltimore after having spent more than 10 years as an interloper in this city, working in the archives, writing the history of this place, found myself all of a sudden a resident of Baltimore. So it was a point of deep reflection even then that there was a resonance between this early history of African American imagination, of activism, of making a way out of no way, that has a deep, deep history in the earliest decades of the 19th century in this city. I didn't know, even in the fall of 2017, how pointed a book titled Birthright Citizens would be in the coming months and coming years. And I know that many of you have been part of, have been witness to, have seen the ways in which the question of who is a citizen and who is not, what the terms of citizenship are, what they might be, what they should be. We have all, as a nation, become caught in this debate. And it turns out, I hope, you'll tell me before we finish today, but I hope that some of the history that I was writing for history's sake helps us to think through the challenges of our own moment. And there are so many moments, aren't there? It was only a week ago, 10 days ago, that Kamala Harris of California, Senator Kamala Harris, announced her bid for the presidency of the United States, and in lightning order, right, within minutes, it seemed, there were those who were prepared to scrutinize not only her birth, but the immigration status of her parents, and to attempt to make the argument that Senator Harris, even as she sits represents in Washington and represents the state of California, that she in fact is not a citizen of the United States by virtue of birthright, because her parents, when she was born, were immigrants to the US, but not yet naturalized citizens themselves. So this is a debate that is of our time, very much generated by a president who, going back at least to 2015, was prepared to scrutinize the terms of the 14th Amendment to the US Constitution that gives us birthright citizenship, to parse that language in not wholly new, but in awkward but powerful ways, and to draw into question the belonging of many Americans, especially including the children of unauthorized immigrants. This question is here, at least with this administration, with this political regime, it is here to stay. And so I'm very happy to talk before I end today about some of the implications of my work, but I want to take you back to the 19th century. And I'm a legal historian, and that might lead you to think that I'm interested in iconic texts like constitutions, acts of Congress, Supreme Court decisions. These are, in the old school of legal history, these were the bread and butter, right? The fodder for legal historians. And there is, of course, a story about birthright citizenship that extends, in a sense, from U.S. Constitution, for example, that was remarkably silent on the question of who is a citizen. The Constitution of 1787 distinguished between free people and enslaved people. It remarked upon Indians or Native Americans, but it never, for example, addressed the question of former slaves, Black Americans who were now free people in the United States, their numbers growing and growing out of the Revolutionary era. The US Constitution was silent on this question about their status. There was a kind of void. Here in the state of Maryland, where we adopt a constitution in 1776, also a kind of silence about citizenship. The Maryland Constitution didn't even use the word citizen when it was adopted in 1776. And this leaves people like former slaves, free African Americans, in a sort of constitutional limbo, in a space that is ill-defined, in a space where anyone and everyone, in a sense, is at liberty to have a point of view about their status, And I'll talk a little bit about how people, if you will, high and low, formally and informally, are contributing to a climate in which former slaves feel themselves very much at risk, feel themselves very vulnerable, because their status before the Constitution, their status before the law, because their place within the nation is at best ill-defined and is also hotly debated. I wrote this book, Birthright Citizens, because in part I wanted to challenge the idea that the answer to the question, who were former slaves before the nation, who were former slaves before in 1868 the Constitution makes them finally birthright citizens, I wanted to challenge the notion that the only people who had a say about that were indeed members of Congress or those who sat on the US Supreme Court. I'm the sort of legal historian who, while I certainly study those sorts of texts, also is of the view that the history of a notion like citizenship is also written by the people closer to the ground, if you will, by ordinary people, by everyday people, for whom the stakes are high, right? For whom the stakes in the view of who is a citizen and who is not are the highest of all, that these too are people who come to law, who study it, who use it as a tool, as a weapon, as a device, as a strategy. I wanted to tell a history of law that was rooted in the experiences of ordinary people that tested their ideas against the ideas that came out of formal legal culture. And that is why I come to Baltimore City. Now, you all know enough about the history of our city to know that by the early 19th century, Baltimore is growing into the third largest city in the United States. It is dynamic in terms of its economy, in terms of its politics. It is also an important seat of legal culture, and some of those well-studied high legal figures like the Chief Justice of the US Supreme Court or the Attorney General of the United States, those folks are Baltimoreans. And so when we think about early Baltimore, we recognize that there's a great deal that happens here that has consequences for the law generally and for the law of citizenship in particular. People are studying this place in their daily lives and then going to Washington to legislate, to dictate, to mandate the terms of national belonging in a formal sense. Baltimore is also a city that is growing into the largest community of former slaves, of free people of color, of free African Americans before the Civil War. If you're at all a student of this question, someone might have tempted you to think that where it was all about was New Orleans, which has its own version of free people of color, a small, influential, oftentimes property-holding elite. No. Some people might have persuaded you that it was Philadelphia you needed to know, because Philadelphia was home to its own free African American elite in that city, a community very important to the anti-slavery movement and the early movements for civil rights. But no, it turns out that our city, Baltimore, Maryland, is home to the largest community of free people of color in the United States before the Civil War, more than 25,000 people on the eve of the war. And I came here as a researcher to ask a question about race, about citizenship, about national belonging. And what I wanted to know was, so what did Black Baltimoreans think about this question? What did they do in response to the challenges to their claims to national belonging? What can we learn when we come to this extraordinary city about the question of race and citizenship in the early decades of the nation? So I want to just spend a little time talking to you about what I've learned I want to introduce you just a little bit. I at least want to tease you with a character out of this book, a man named George Hackett. But I want to use him to illustrate some of what I discovered here in Baltimore. The first lesson for us, I think, is that questions about citizenship in the history of the United States have never been purely academic questions. Never have they been purely questions of jurisprudence or of political theory. That in this country, we come to the question of citizenship in moments of crisis, in moments of strife, in moments of tension. That is part of this history. So anyone who tries to speak to you about citizenship and begins to invoke the abstractions and the learned writings, don't be fooled. We only talk about this question when on the ground we have a crisis. So what's happening here in Baltimore in the 1820s when free African Americans begin to deliberate? They do so in newspapers. They do so in political conventions. They do so, I suspect, on the streets and in parlors, though that's harder for a historian to recover. But there is a robust debate beginning in the 1820s in this city about the terms of belonging, whether or not Black Americans also have a permanent claim to the city, to the state, and to the nation. Well, there are two things going on. The first is a movement that we call colonization. The colonization movement has a long intellectual history, but by the 1820s, it has taken institutional form, an American Colonization Society and a companion Maryland Colonization Society. Colonizationists are a curious but ubiquitous bunch before the Civil War. What do they believe? They believe that slavery will inevitably end. Some of them believe slavery should end very soon, very quickly. Others of them will give slavery another 100 years to work itself out. But all colonizationists believe that slavery will eventually end in the United States. And as a consequence, they want to then determine the future of former slaves in the U.S., and their solution is that they should be removed. Colonizationists organize. In Maryland, with state dollars, they organize to outfit ships, to offer inducements. They establish a colony in West Africa called Maryland in Liberia, and they devote themselves passionately, earnestly, again, with public dollars in this state, to ensure that whatever slavery's fate might be, that the U.S. will, going forward, always be a white man's country. So if you're an African American, a free African American in the city of Baltimore, you feel keenly this pressure to remove you, persuade you, coerce you, entice you into leaving. So this is one reason you might turn to citizenship as a kind of defense against the pressures of colonization. The second pressure comes from what we come to call Black laws. So here, before the Civil War, the Maryland state legislature will gather itself from time to time, certainly by the 1820s in earnest, and begin to regulate in great detail the everyday lives of former slaves. What sort of job one can have, how to organize your family and raise your children, whether or not you can travel and move about, whether you can come together in public assemblies like church or political meetings, whether you can own a gun or a dog. All of these kind of everyday matters become the fodder, if you will, for Black laws. And Black Marylanders come to understand that these Black laws are intended to be, in a sense, the regulation of everyday life. But collectively, as a whole, they are like colonization, intended to create a set of pressures that will lead former slaves to self-deport, right? To exile themselves to Canada, to the Caribbean, or to West Africa. These are the conditions, right? This is the pressure that leads Black Baltimoreans to turn to the question of citizenship, to begin to consult themselves, but to work with lawyers and judges, and to begin to build the case that they indeed are birthright citizens. They scrutinize the Constitution, and curiously, they discover that now not so infrequently invoked requirement that the president be a natural-born citizen. And they say, well, if the president is a natural-born citizen, there must be such a thing, and aren't we natural-born citizens too? And with this insight, they begin to build their case. Probably the most often invoked answer to the question, were these men and women citizens, comes in the form of a notorious US Supreme Court decision called Dred Scott versus Sanford. Dred Scott is a Missouri case that makes its way all the way to the US Supreme Court in 1857. There's much to say about that case, but for our purposes, and for the purposes of free Black Baltimoreans, the most chilling, the most arresting element of that Supreme Court decision is the moment in which Roger Taney, a Baltimorean, concludes that no Black American, be they enslaved or free, can be a citizen of the United States. It's a devastating blow, certainly in a psychic sense. It doesn't bode well for former slaves going forward after 1857. But I asked myself, so what did Black Baltimoreans do? And the answer is they continued to do what they had been doing for decades. They continued to make the case for their citizenship by way of the written word, newspapers, tracts, books. They continued to gather in political conventions to make the case, build their argument, build political allies in the public sphere. They spent a lot of time in our local courthouse, which stood just where the courthouse stands today, though it was a much more modest structure. And there, the claim to belonging, the claim to rights, the claim to a relationship to law and the Constitution was every day and everywhere. Whether they were coming in to take out permits for their guns or their dogs or to travel, or they were coming in to challenge apprenticeship contracts which controlled the education and the training of their children, whether they came in to enforce a contract or declare bankruptcy, former slaves are in the courthouse every day in that day-to-day way, making the case, A, we're not going anywhere, and B, we are going to make a way, insist on our belonging and upon our rights in the ways that we can in this local courthouse. So a lot of this book recounts their stories, recounts their activism, looks at the way in which former slaves used the courthouse to make the case for their rights. The third lesson is about the limits of any political reality, which is to say, before the Civil War in Black Baltimore, the way to make your rights was never a sure thing, was always a contest. You might, one week, have in your hand a judge-approved travel permit that permitted you to leave the state and return despite the Black laws. But the next month, you might find yourself bumping up against a local constable who was going to challenge your right to come together, for example, in a church service on Sunday afternoon. It was a tough place for that. But part of what I admire about this city and this community is that people stay put. And much in the ways that enslaved people watched and waited for their own opportunities for emancipation during these decades, free people of color watched and waited for their opportunities to make the full claim for citizenship. So the book ends with a brief look at what happens after the beginning of the Civil War, the era of Reconstruction, the abolition of slavery, and what we discover is Black Baltimoreans now making full-throated claims to citizenship, lobbying in Annapolis to defeat Black laws, appearing in courthouses, now not only asking for relief from onerous apprenticeship arrangements, but also asking that apprenticeship laws be declared unconstitutional, which they are. They are lobbying here in the City Council for public education, schools for African American children, something that they had long been taxed for, but never been permitted to enjoy. African American men, for the first time, are organizing themselves into private militias. They are bearing arms in the city streets, parading and displaying their claim to citizenship in wholly new ways in the era after the Civil War. So the last lesson is really, I guess, about the sense of what time means in the kinds of stories we tell about our past. A story that begins in the beginning of the 19th century, which, with the disenfranchisement of African American men in the state constitution in 1802, moves all the way forward to 1862 and beyond, where we see Black Baltimoreans, in a sense, continuing to push the edge of the envelope, not waiting for Congress, not waiting for the Supreme Court, but continuing still to make their way out of this place. I want to be sure we have some time for questions, so I'll just end with a few suggestions, I guess, about where this history might take us. The first one is, I guess I'd say, about the nature of American democracy. And I think what I learned in this work is that in a democracy, it is always true. It is always true in any era that there are people who are deemed outside, in my story, former slaves, who are trying to figure out how to get in, right? And sometimes they knock on the door. Sometimes they make a lot of noise. Sometimes, in my story, they nearly take out, at least metaphorically, a battering ram. But there is nothing contradictory in a democracy about the fact, in our democracy, about the fact that there are people outside who want to get in, who want to become members of the body politic. And oftentimes, as in my story, they are on the cutting edge of defining what our democracy is. In my story, it takes many decades for lawmakers in Washington to catch up, right? To hear the argument that former slaves have been making all along. It'll be 1868 when Congress will finally see ratified the 14th Amendment that makes birthright citizenship the law in a formal sense in the United States. But by looking at the history, we understand that it was former slaves themselves who developed that concept, who promoted it, who kept it on the table, who pushed and pushed, even in the face of those who told them they were out of bounds and outside the bounds of the Constitution. So a democracy, and the story of democracy, is about people trying to get in. And I guess relatedly, then, struggles over who is in, struggles over citizenship should not be a surprise to us, because our history tells us that in any era, struggles over citizenship are going to be part of the story. We live now in 2019 in a latest chapter of that. One, I think we're not yet certain about its resolution or what its resolution will be, but we can be sure that citizenship and questions about it will be part of our national conversation and our national debate for as long as we are a nation. The last bit is about birthright itself. Part of the kinds of conversations I've had the privilege of having in these last months have been to do some very fundamental work, which is to remind Americans that the 14th Amendment and birthright citizenship is not an accident. It wasn't just some excess of Congress. It wasn't an afterthought. Birthright citizenship in 1868 was a bold, a dramatic, a powerful gesture at reimagining our democracy. It made 4.5 million Black Americans Americans, right, unassailably by virtue of their birthright. This is no accident, I would say. It's probably one of the, I don't know, choose your top 10, right, moments, right, in which this nation manages to embody its best ideals. Birthright citizenship is, for me, one of those moments. And at the same time, I think what I've learned in talking to audiences is that actually folks aren't completely persuaded that just because it's the way we've done things since 1868, it's the way we should do things forever. Fair enough. Right, fair enough. And so I think there is a challenge for those of us who defend and advocate for the birthright regime and its realization in its most robust form, its most inclusive form. We need to be able to articulate what it is we are fighting for, what it is we are defending in the 21st century, and not simply in the 19th century. And so the last thing I'll offer you is a view of what birthright has given us, right? Which is not an ideal regime at all, right? Not an ideal regime. And there are many reasons to think critically about what birthright doesn't accomplish in the 21st century. But short of that, I want to at least suggest to you that what birthright does for us is fuel a democracy whose citizenry, to a very important degree, is comprised of people who are not subject to any sort of litmus test. Now, in the 19th century, Congress intended to wipe away the litmus test that was race. Right? Blackness would no longer be a political disability and keep one from being a citizen. Congress intended to wipe away what they called the previous condition of servitude, which is to say, even if you had one time been enslaved, by virtue of birthright, you were a citizen of the United States, right? Having been enslaved was not a disqualifier. But think about the history of our country going forward from 1868, pick anything, any moment in time, and you know that if former slaves were despised Americans in 1868, they certainly never cornered the market, unfortunately, on who might be a despised American. And what birthright did was ensure that even the children of despised Americans, of vilified Americans, are citizens of the United States. My many examples. This will be true for Chinese Americans in the latter part of the 19th century, who will be said to be indelibly foreign and hence not eligible for birthright citizenship. No. Even as Chinese immigrants to the United States after 1882 are said to be so foreign that they cannot naturalize ever as citizens, right? That is the state of play in the US. Even the citizens of those Chinese immigrants who cannot themselves become citizens are citizens of the United States, right? Anti-Chinese racism, xenophobia is rampant in this period and has grave consequences for Chinese Americans, but the children of Chinese immigrants are citizens unassailably of the United States. In the early 20th century, in the era, too long an era of Red Scares, the children of Communist Party members despised, marginalized, arrested, discredited. The children of Communist Party members in the United States are citizens of the United States, even as their parents are despised. And in our own lifetimes, after so-called 9/11, when Muslim Americans now step into that regrettable set of shoes, right, that puts them among despised Americans, even the children of Muslim Americans born in the United States are citizens of the United States unassailably. And this, to me, is a principle worth considering and worth defending. In a nation that has only proven to us its capacity, its infinite capacity, to identify and despise others, cyclically, periodically, changing over time, don't we want a citizenship regime that insulates new citizens from the litmus test, be it race, be it political affiliations or beliefs, be it wealth or health? Don't we want a regime that is not subject to the political whims of a given moment, to the xenophobia and the racism of any moment? Don't we want that possibility for the future of a democracy that does not honor those kinds of differences, at least in its broad strokes? So I think that I'll stop. The dean is smiling, so I think I'm right on time, I hope. So I want to say thank you very much, and I'm very happy to take questions or comments, as you will. Thank you. And I think, how am I doing?
Doing great.
With this is working? Good. Great, thank you. So comments, Kai.
I was curious, so as I understand.
Yeah, there's a microphone.
Thank you. As I understand, birthright citizenship is much more common in the Western Hemisphere, generally the New World. And so, part of the motivation for it was attracting immigrants in general. And if you look at the Eastern Hemisphere, much fewer countries, as I understand, have that as law. Would you say that there's going to be any point in U.S. history where the idea of attracting immigrants is, more similar to how it's seen in Europe or in, the countries where there is no birthright citizenship?
So birthright citizenship is not intended to attract immigrants at all. Birthright citizenship its purpose is to make former slaves citizens. Prior to the 14th Amendment, immigrants have no trouble. European immigrants in particular have no trouble entering the United States. Naturalization is as simple as walking down to the local courthouse, standing in front of a judge, renouncing your allegiances, and heading the next day to the polls. So birthright citizenship comes to function certainly for immigrants, as a protection for their children, but its purpose is not that. We are at a crossroads, right, on this question, right, and weighing, right, the relative benefits to our democracy of a birthright regime. You are right that in the last decades, Western Europe has rethought birthright, debating it, curtailed it, now talking about bringing it back in places like Ireland. So it's to say that it goes to my point, right? In democracy, the question of citizenship and who's in and who's out is a perennial one, right? It is not one that gets settled and fixed and we march forward. But today, birthright is still the predominant regime in the Americas, and we would be an outlier in the Americas if we were to step away from birthright. So thank you so much for that.
Hi,
Hi.
I'm Karen Thomas. I'm this historian of the Bloomberg School, and I thought your talk was just absolutely terrific. I'm going to go get your book, but I'm interested to hear more about the actual content of the arguments that the free people in Baltimore were making to try to convince, I'm assuming, white officials or other people who held power to decide that. How are they arguing that they deserve to be citizens? Mm-hmm. And it seems to me that, because you were just talking about, European immigrants came and it was straightforward. Part of the reason for that is there's such a huge need for labor. Mm-hmm. So I was wondering, was labor part of their arguments that, we're here, we're able to help build the country? And then the other flip side of that, which relates to our own school and what we do, is health. Because one of the reasons that, whether it's Chinese Exclusion Act or the current treatment of people seeking asylum at the border, is a fear of contamination or a fear that immigrants are bringing, bad health into the country. So were the people in Baltimore faced with those kinds of prejudices, even as they were working very hard physical labor to make a living? Thanks.
Okay, so a lot there, but let me try quickly. On the latter part, there are white officials in the state of Maryland who are deeply concerned about contagion. That's a word you all must be in your vocabulary. But what do they mean by contagion? They are concerned that free people of color will contaminate enslaved people by inspiring them to rise up. So when they use the metaphor of contagion, what they are really talking about is a kind of political contagion. And so containing, constraining, removing free people of color, it is hoped will leave those remaining enslaved people in Maryland, many of them now in the South and the eastern part of the state, will insulate them from the kind of contagion of freedom, which is what free people of color embody. Now, the other part of your question was about what is the argument that they're making. They make lots of arguments. This is what I mean about, these are not folks who are political philosophers, right? They are not writing legal treatises. They are trying a lot of things. They certainly make the argument that their labor, for some of them, long unrequited labor as enslaved people before they were free, should be the ticket, if you will, to citizenship. Others of them will make the argument that military service should be the ticket to citizenship. And in Baltimore, we have men who are veterans, both of the American Revolution and, of course, the War of 1812, who have done service in the military context to the nation. They argue this as well. The argument that gets them traction, however, is this close reading of the Constitution. It is this somewhat more cerebral but powerful argument. And why that argument gets traction, and it does get traction among some white officials, is precisely because these are men and women who, by the eve of the Civil War, number 90,000 in the state of Maryland, 25,000 of them here in Baltimore, who are workers and are part of the engine of prosperity in this state. And the Maryland High Court, the Court of Appeals in 1858, looks at this question. It asks, should we sort of basically go with Justice Taney and say, no black people in our courts? And the High Court says, absolutely not. Because why would free people labor if they could arbitrarily be deprived of their wages or their property? Right? They need to have access to our courts in order to defend their persons and their property, and the courts in Maryland stay open. There's a second argument, and I hope this resonates a little bit in 2019. The second argument that comes from a former slaveholding colonizationist in Annapolis at the top of the High Court, John Carroll LeGrand. LeGrand says, there's no future for the state of Maryland if we, in one fell swoop, transform free people of color into outlaws. There is no future in an ordered sense, in a prosperous sense, right? In a legitimate sense, if we transform people into folks who have no recourse before the law. People will still figure out how to resolve their disputes. They will have disputes, they will figure out how to resolve them. But we cannot hope to be a state with any sort of integrity if we transform people into outlaws, people outside the law who live in the shadows, that this is a formula for social undoing and social unrest. And in the state of Maryland, despite Dred Scott, the court won't permit that to happen here. So thank you so much for the question.
Hi.
Oh, hi.
Hi. Thank you so much for your talk. It was really, really elucidating. Looking forward to reading the book. My question is about the legal landscape that folks found themselves in from the beginning. Do we have any records as to why the Constitution was silent about who's a citizen and who's not, and the Maryland Constitution as well?
What do we know? The answer is no. That's too simple. The answer is no. And for a long time, the view was, among historians, the view was that citizenship was just not a particularly germane question, that rights didn't particularly flow from citizenship. It's hard to remember. In early America, for example, one need not be a citizen to vote in most states. That is an evolution. That is something that emerges across time. So one argument is that there's a sense that very little flows from citizenship. It's not a great question or concern. There aren't big stakes in it, and that's why there is so much silence about it. Which I think might be right, and why the question becomes not only of interest to former slaves, but becomes of interest to Congress, becomes interest to courts, treatise writers after the 1820s, because now free people of color are beginning to make the kind of noise that suggests, oh, indeed, there are stakes in who is a citizen and who is not, and what rights might flow therefrom. So it is, how would you say, an iterative process. But it begins with this curious blank slate that leaves a lot of room for debate. So thank you for that.
Thank you. That was really an incredible talk. So I was wondering if you could explain something to me, because I'm not sure I understand it. With this question as it's coming up now, recently, there have been some who have said that there's a clause in the 14th Amendment that really questions the whole birthright. And I don't understand that. And my question is, could you explain that? And also, how risky is that? Has that been brought up before?
Right.
What are we talking about?
Right. So the first thing I say, I can't give legal advice. I don't have malpractice insurance anymore. So I give common sense advice, which I think in this political moment is hope for the best and prepare for the worst. Right? Because I don't think we know if, and I'll address the specifics in a second, but I don't think we know how this particular debate in this climate with this Supreme Court, this administration, I don't think we know. And anybody who says to you, oh, that's unconstitutional, anybody who says to you the president is an idiot, he doesn't know what he's talking about, is not giving you the right advice, in my view. Hope for the best, right? Hope that the political winds shift and this comes off the table. But for people who are on the front lines, our families, our friends, our neighbors, our clients, people need to have in their mind how they are prepared for the worst. What's going on? It predates Trump, it's important to say. But there's long now been a movement to interpret this phrase in the 14th Amendment that makes an exception for some people. Not everybody born in the US is a birthright citizen. People not subject to the jurisdiction of the United States are not birthright citizens. In 1868, what Congress meant was three things. It meant the children of foreign diplomats who just by chance were born in the US were not birthright citizens, right? They were citizens of their own, well, their citizenship was to be arbitrated by their own nation. Congress was thinking about occupying armies, not something that has come up much in our history, but Congress is clear that should the US be occupied by a foreign army, should children be born, those children are not birthright citizens. The third category are Native Americans or Indians. And here Congress is mostly gesturing at a respect for Native sovereignty, which is to say Congress does not, with the 14th Amendment, reach into or behind the sovereignty of Native nations to deem Native people citizens. That question is one that will get decided in the 20th century. So there is this language. And what happens after Reconstruction and beginning in the 1870s and picks up in the 1880s is this language gets used to prohibit Chinese Americans born in the US, but born to non-citizen parents. Wong Kim Ark is the man who goes to the Supreme Court on this case. He's born in San Francisco. He goes to China. The first time, he comes back into the port of San Francisco, no problem. Second time he comes back, he's stopped. And customs officials have taken the view that this language excludes Wong Kim Ark because, they say, the children of Chinese immigrants, people who are not eligible themselves to become citizens, their children are also not eligible to be citizens, not subject to the jurisdiction of the United States. The Supreme Court in 1899 says, no, Wong Kim Ark is a citizen. So I know it's a long build-up, but it's worth it. What's happening now is that we've come back to this language. And there are a couple of questions. Who has the power to interpret that language? President Trump thinks that he does by way of an executive order, I hear tell. Congress thinks that it might. And certainly the US Supreme Court, the courts have the ability. So one question is who has the right, the power, the authority to interpret this language? I don't think, it's not a settled question, as we say. More to the point, there are those who have argued that this language excludes the children of unauthorized immigrants in the United States, born in the United States. And they are attempting to make a distinction between, if you will, the facts of Wong Kim Ark and the facts of the families of unauthorized immigrants today. How do they do that? Wong Kim Ark's parents were not citizens. They weren't eligible to be citizens by federal law, but they were authorized immigrants. And the court goes to some length in the decision of Wong Kim Ark to explain that Wong Kim Ark's parents are authorized to be in the United States. They do the kind of work and carry on the kind of business that is expected and is consistent with their authorized residency in the United States. So you see, this is what lawyers do. I don't defend it. It's what we do, right? Is we try and distinguish and argue the tension between the facts and the law. And this is the argument that is being made. It is being made by the president, who thinks that he can, by executive order, interpret this clause and direct his agencies to then do business, right, by way of his interpretation. There has been now, for the last 10 years, every year, there is a bill introduced in Congress that proposes to interpret this language in the way that, in this narrow way that I've just described. This year, it was introduced by Steve King. I don't know if anybody, so I'm not sure it's going to go anywhere. King has been pretty much eviscerated of any kind of influence in Congress right about now. But he's not the first to propose it, and he likely won't be the last, and he had many co-sponsors to the bill. So there's a bill live in Washington today that would, that proposes that Congress should interpret this clause and should interpret it such that the children of unauthorized immigrants are not birthright citizens. And then we have a new Supreme Court, right, that is untested on many questions, including this one. And while the record of this court will evolve and we'll know more and more about how it's thinking about a range of questions, this is what we call a question of first impression for the US Supreme Court, and I certainly don't think I'm confident enough to say how it would. So hope for the best, right? There's lots of work to do, right? There's lots of work to do, worthwhile and important work to do, but part of it is helping people be prepared for all sorts of eventualities. So, sorry, long answer, but.
That was terrific, and thank you so much. I think, from my perspective, not only the subject that you're talking about, but also the story and the inspiration, that what really matters in this isn't just the decision that gets made by somebody who is at the top of a political hierarchy, but that people can really work from many angles to make a difference on this, and maybe to take a bit of the long view and not be discouraged by even very difficult things that happen.
Yeah.
Please join me in thanking Professor Jones for coming.